Hello, everyone. Welcome to Arnold and Porter's webinar in ESG investigations, internal investigations and risk management. My name is Brian Israel. I am the head of the environmental practice group at Arnold and Porter based in DC and Los Angeles. I also co-lead our ESG practice group. Before we get started, I'd like to just go over a couple of housekeeping notes. If you'd like to submit a question, we'd love to have your questions. Simply select the Q&A icon located at the bottom of your screen and type in the question. We're gonna try to get to everybody's questions. If there are a lot of questions, we may contact you after the webinar. There will be an ebook which will contain today's presentation slides, our bios, additional materials, which will be circulated after the webinar. Also, if anyone is seeking CLE credit, the instructions on how to submit your request for CLE credit will be included in the follow-up email. So just before we get started, I'd like to introduce our esteemed panelists. We have with us today Christian Schultz, who is a partner in our DC office, and Sasha Zhang, a senior associate in our New York office. And maybe you could each introduce yourselves briefly, and we'll get started.
Thanks, Brian. Thanks for including us in this panel. As Brian said, I'm Christian Schultz. I'm a partner in Washington, D.C. I joined Arnold and Porter about 15 months ago from the Securities and Exchange Commission, where I was Assistant Chief Litigation Counsel for the decade prior to joining Arnold and Porter. And before that, I worked at another major DC law firm and did a number of internal investigations in the course of that work.
Sasha.
Thanks, Brian and Christian. I'm a senior associate in the same group as Christian, and I'm excited to talk to you about ESG issues today.
Yeah, okay, so let's get started with the next slide. Just a couple things about this webinar. It's a 4-part series. And you're welcome to get the recordings from the other sessions. We held one in April on state AG, antitrust, and FTC investigations, in May on congressional investigations. Today's topic is internal investigations, as well as some advertising and enterprise risk issues, which I'll speak about briefly. And then we'll have a 4th webinar coming up on SEC investigations. Also, just to put this in further context, we Arnold and Porter will be publishing a book through the ABA and later this year with 25 chapters or so on a variety of ESG related topics, including many of the topics that we're talking about in the webinar. Next slide, please. I think everyone is familiar with what ESG refers to. Broadly speaking, ESG refers to both investment imperatives as well as internally derived goals related to environmental issues, frequently sustainability, as well as other environmental issues, social goals, including diversity and inclusion, human rights, and other human welfare and employee welfare issues, and governance, which really addresses how companies are managing and directing objectives with respect to either environmental or social issues. And of course, broadly speaking, ESG asks a much deeper question about what is the role of a company in society. And as we all know, there's quite a bit of political attention on ESG related issues, including what's sometimes referred to as the ESG backlash, which is essentially the argument that companies should be focused simply on increasing shareholder value and less so on ESG related objectives. In the book, you'll see there's a lot of history to ESG. It's not actually a new thing. ESG goes back to really the beginning of the establishment of companies. Since the beginning of the corporate form, companies have struggled to understand their responsibilities to the broader community. And I think it's a very interesting jurisprudential policy question. We're not going to have time today to talk about that in great detail, but it's worth noting. Next slide, please. Whatever one thinks about ESG, the numbers are pretty compelling. As I like to say, it's hard to argue with $17 trillion, which is, as of, I think, 2021, the size of the investment community that is concerned about ESG related issues in one form or another. And as you can see from these numbers, a trend of attention by investors, funds, professionals of all sorts, companies themselves focused on ESG related topics. So next slide, please, Laura. So I'm going to talk for a few minutes about what I call enterprise risk related to particularly green claims, but also more generally, and then I'll turn it over to Christian and Sasha to talk about what to do if you get such a claim and how to structure an internal investigation. I think it's quite clear that there is increased scrutiny on ESG related statements, including statements on a company's website, public reports and filings and advertising. I'm going to give a few examples. The case law is quite mixed at this point, but it's also fair to say that we are in a moment in time on a journey, and how these cases will play out ultimately remains to be seen. There are all sorts of risks related to ESG related statements, including litigation, as we'll talk about, fines, market valuation loss or impacts to brand, employee and customer disengagement, and then the ESG backlash, which makes navigating how to talk about one's ESG objectives quite complicated. It was complicated before, but if you're dealing with the risk of being attacked from either direction or many directions, the attention to detail, the caution, and in some cases the humility that's required is even more salient than it might have been before. Just a few examples. The next slide, please. I think many of you may be familiar with the climate related claims in the Chevron case. This is a recent incident or filing by environmental groups submitted to the FTC, alleging that Chevron was misleading consumers on climate action. This was not a filing by the FTC. This was essentially a request by environmental groups for the FTC to open an investigation. The request claimed that Chevron was misleading customers by using phrases such as ever cleaner energy, higher returns, lower carbon, and other phrases. The group specifically pointed to social media promotions, television, and digital ads. And there were a number of specific objections and allegations of deception, et cetera. There's not actually a lot that's publicly available with respect to how the FTC handled, except the FTC did not pursue or has not pursued a claim against Chevron, and it appears that this case did not go anywhere. Next slide, please. This is a more recent, just filed lawsuit, class action targeting Delta in particular, and with respect to its carbon neutral claims. Specifically, the plaintiff here is alleging that through ads and press releases, social media, et cetera, that Delta was misleading consumers and the public by claiming to be the first carbon neutral airline, and that Delta was grossly misstating its actual carbon reduction, principally because Delta, at least at the time, was relying upon carbon offsets. And the carbon offsets, as you may know, are when an entity will purchase will purchase credit, essentially carbon credits, or through either for reforestation or prevention of deforestation or many other activities to essentially balance out the carbon emissions from the enterprise. And there are many questions about how carbon offsets are calculated and whether they constitute a carbon neutrality, and when would they, and how do you guarantee the validity of the offset? So this is in the allegations. The plaintiff is arguing that these are speculative. This is clearly in the early stages, so we'll come back and report on how this turns out. But clearly, this is part of a trend toward making claims of often called greenwashing claims about how companies are articulating their carbon neutrality objectives. Okay, next slide, please. H&M, this is interesting. This is really related to sustainability claims. Very interesting lawsuit, which was just dismissed last month, where the plaintiff here the plaintiff alleged that that they purchased an H&M sweater in reliance upon the assertion that it was a conscious choice, when in fact the sweater included was not in fact environmentally friendly or sustainable. The court, it's a very interesting decision. To the extent that there was any misleading of anybody, the court seemed to very closely imply that the plaintiff was misleading the court, because the plaintiff kept using the term environmentally friendly and sustainable, when in fact H&M never used those terms. H&M very, very carefully crafted its statement in a way that was, at least not even according to the allegations, incorrect. Simply saying that there was more sustainable or recycled material in the conscious choice line of clothing. You had a number of different qualifications for what that meant. And interestingly enough, H&M even said on their website, this is interesting, so I'm going to read it. H&M actually tells its consumers the opposite, that fashion has a huge impact on the environment, and that the only trends worth following are recycling and repairing clothes. So H&M was quite clear that that its products do have an impact on the environment, and we're simply saying that if you purchase this particular line of clothing, that it's its most sustainable line. So that's an interesting line of case, or interesting case in this line of cases. Next slide, please. Coca-Cola, another case where there was a dismissal. In this case, the statements, this was in DC court, dismissed last year. What really was the essence of this litigation, or this dismissal, was the court's determination that the sustainability statements by Coca-Cola were aspirational, that they were not specifically concrete to be deceptive, that they were simply stating goals, and they were also significantly in the future. This is one of the reasons why it's really important to understand different jurisdictions, because different jurisdictions have different, particularly with consumer protection laws, but also with the FTC green guides there, and in Europe, there are really different expectations as to how one can frame aspirational objectives. Next slide. Canada Goose, another interesting case here, where there was actually the plaintiff survived the initial pleading stage. The complaint stated, Canada Goose stated that it was dedicated to ethical, responsible, and sustainable sourcing and use of real fur. The lawsuit alleged the statement was misleading, because the company allegedly used inhumane trapping for its fur. The case is still pending. So we'll keep an eye on that. Next slide. The last case I'll talk about is also a still pending case where called is a KLM case where a Dutch agency determined that the tagline "Be a Hero, Fly CO2 Zero" was misleading because it was an absolute claim, and according to the agency, KLM had not proven the statements. The environmental groups subsequently filed a similar claim for the Fly Responsibly campaign, which KLM has stopped using, and the court has allowed that claim to proceed. It really is one of the first times that an environmental NGO has been allowed to bring a claim under a new Dutch class action law. And so this one is has survived, and we'll kind of wait to see what happens with the court. But it's clear that there's at least currently a more likely for greenwashing type claims to proceed and at least in Dutch courts. And then just a couple of takeaways before I turn over to Christian and Sasha. Next slide, please. Yeah, perfect. Thanks, Laura. So a couple of takeaways. First of all, I think most people are aware of the FTC Green Guides, which provides a very specific guidance on how to ensure that claims are truthful and not misleading with respect to products and services, not necessarily related to overall enterprise issues and omissions, but when talking about a particular product or service, the FTC guides is a good place to start to seek guidance if it's related to an environmental issue. And there's similar directives in other jurisdictions. Just a note, FTC guides are, the Biden administration has indicated that they are likely to revise the green guides. They've been in place for many years, but we expect that the FTC will be updating the green guides and will likely address other climate-related claims, including consistency across an enterprise. So, of course, just a few takeaways that are worth remembering when marketing and making assertions related to either environmental or social issues. One is to be clear and understandable. Ambiguity is not necessarily helpful. Of course, I highlight a couple of cases where because the claims were vague and aspirational, they were not held to be a violation of particular consumer protection statutes. So it will depend, of course, on the specific claim. It is important to distinguish between the benefits of particular products and specify what it is, or services or packaging, so that there's not an implication that when you're talking about one particular product or service, that you're implying that this is necessarily true for other products and services in your company. Of course, not overstating either directly or by implication any negligible benefits, and the case law is very worried about statements that are touting negligible benefits as overstating or creating an impression that in a reasonable consumer's mind that may not be accurate. And then pay attention to business-wide activities, ensuring congruence with the company's overall business. And this really gets to the point that you can be completely accurate, you can be completely consistent with the green guides, you can be completely consistent with consumer protection statute, but if you're only talking about one small piece of the company's overall business and giving an impression with respect to the entirety of the business, you could be susceptible to allegations that you're misleading or you're failing to provide context and congruency with overall enterprise. Of course, a major focus of the FTC Green Guides is to substantiate the basis for any claim and to be able to do that in a verifiable way. General claims such as eco-friendly and green, as well as aspirational statements, these are, again, attention to the particular jurisdiction, the particular context is very important. In some cases, aspirational statements can be helpful. In other cases, such as FTC, one has to be quite careful not to give an impression without specificity. Legalistic precision is not necessarily sufficient, and again, you have to consider inferences, and as I said before, omissions can be deceptive. And then lastly, ensuring consistency across the enterprise, but also over time is very important. So a statement today can be vetted internally. You could have assurances that it's accurate today, but like with any compliance program, one really needs a management system, essentially an ESG management system, similar to a compliance management system, to ensure that whatever it is you're saying today will stand the test of time and also evolve as the company evolves. So that's just a few takeaways on ESG communications and enterprise risk. And I think that I'm going to turn over to Christian and Sasha to talk about what to do when you have an investigation.
Thanks, Brian. Laura, can you go to the next slide? So there's, as we see it, kind of three areas that are, reflecting ESG stakeholder scrutiny can be a source of internal investigation activity within a company: shareholder activism, government scrutiny, employee expectations. And I think really employee expectations could be expanded to include employee and customer expectations or consumer expectations. A number of the cases that Brian just walked through sort of reflect the consumer expectations and customer expectations that could ultimately lead to internal investigations. Next slide, please. From a shareholder activism perspective, we've seen a number of instances, several are highlighted here, where there have been proposals put forth at annual meetings of different companies relating to ESG issues, either for or against proposals by the board or by activist investors who want to, emphasize an ESG issue with respect to either company governance or investment activities. I think we saw that research by BlackRock showed that 3/4 of proposals that were made at annual meetings that received 30% of votes from investors led to companies taking action on those issues. Next slide, please. From a government scrutiny perspective, the SEC is obviously my area of experience and expertise. Brian's best practices relating to ESG related communications really dovetails with the government scrutiny issue. Currently, the SEC requires reporting companies to make certain disclosures about compliance with environmental laws, use of conflict minerals, human capital management, board structure and composition, executive compensation, and pay ratio. And a number of the points Brian made about best practices would play into how reporting companies are conveying messages to the public and to investors on these issues. The SEC has also proposed rules that would require disclosure of more information about climate risks and opportunities, including GHG emissions and climate-related financial metrics. Those are still in the proposal stage. We think the final rules are going to come out later this year or early next year. The news seems to fluctuate on when that will happen. And then the SEC has also expanded the names rule to require funds that invest in certain ESG related issues, or if the name of a fund suggests something particularly ESG related, that 80% of the investments made by that fund actually comply with the idea behind the name of the fund. So if it's a sustainability fund, that 80% of those investments in that fund would be in something that is verifiably sustainable. Next slide. Sasha, do you want to talk a little bit about how to conduct an internal investigation?
Sure. Thank you, Christian. So I think many of you on this call will already be familiar with the process of conducting an internal investigation. And an investigation into ESG issues will probably be quite similar to what you're used to. So I'll just go over some high-level tips and pointers. Next slide, please. One of the first things that you want to think about when you are deciding whether how to conduct your internal investigation is whether you want to handle an investigation in-house or if you want to retain outside counsel. So the answer to this is that it depends. I think, can you go back one slide, Laura? Oh, okay, never mind. You can go forward one slide. So on one hand, could you go back one slide? Sorry, Laura. I think we're missing a slide here, but that's okay. So I'll just go back to talking about how we decide between whether you want to hire outside counsel or in-house counsel to do the internal investigation. So on one hand, in-house counsel can conduct an investigation faster and more efficiently. They already know the actors and they tend to know the facts. And on the other hand, outside counsel often have subject matter expertise. They could have regulatory experience like Christian, and they can help overburden in-house legal departments. And also hiring outside counsel can also help preserve attorney-client privilege and work product protection, especially where the in-house legal department isn't clearly separate from a compliance function. And one other thing to think about is who should be supervising the internal investigation, whether that's the GC, a committee of independent directors, or an audit committee. So now looking at this slide, after the company decides whether to hire counsel or even before, what you want to do is make sure that documents are preserved. You'll want to stop any auto-delete processes. You'll want to send out a doc hold notice to the right people. You'll want to work with IT or outside counsel on collecting materials, and you'll also want to put together a plan of document review. Next slide, please. So reviewing documents and hopefully locating some interesting ones leads to the stage of the investigation, which is employee interviews. And this can also happen at the same time as the document review and analysis. We often have in-house counsel sit in on employee interviews, but in certain instances, it can make sense for these to be handled solely by outside counsel if you've retained one. Employee interviews can often last anywhere from half an hour to multiple days, or they can be split up across days, and it can be an iterative process that counsel should clearly be prepared for. Next slide, please. One interesting issue that comes up is the attempt to preserve the confidentiality of an investigation, which is particularly important where ESG issues are at stake, because ESG issues are some of the most politically and socially sensitive issues out there. So understandably, you don't want everyone talking about the investigation, especially before it's concluded. One way that companies try to protect the confidentiality of an investigation is to get employees to sign confidentiality statements with warnings that they could be fired or face other discipline if they discuss the matters with outside parties. But you have to be very careful about the way you word your confidentiality statement. For example, in one case listed here where the confidentiality statement didn't provide an exception for discussing the investigation with regulators, the SEC said that the company violated Rule 21-17 of the Exchange Act, which prohibits any person from impeding an individual from communicating directly with the SEC about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement. In this particular case, the company was fined $130,000 for having employees sign this confidentiality statement. So that's something you want to watch out for. Next slide, please. I'll turn this back to Christian.
Thanks, Sasha. One of the things I wanted to add to the point that you were talking about in terms of employee interviews, there's often a question about who should conduct those interviews. And, it can really be, it's a case-by-case basis on whether or not to have in-house counsel conduct those interviews, outside counsel for the company, or in some instances, if you have an employee who already has separate counsel, may go about conducting those interviews, the interview themselves with that employee, and reporting back to the company and providing information to assist the company's investigation. And another question that we often get asked is, where should you start an internal investigation? We typically recommend starting with lower level employees, principally because they're closer connected to the facts and understand the operations and the implementation of management decisions. If they're not implicated in conduct by senior management, they may be more willing to speak with counsel, whether in-house counsel or outside counsel. And they may be able to assist with obtaining key documents, as they're more typically involved in record keeping, and also typically have more time to assist with an investigation than senior level people. One exception would be if there's an internal whistleblower. We would strongly recommend interviewing the whistleblower first, regardless of seniority, to really be able to get a sense of what the underlying issue is in the claims that are being alleged, either in an internal whistleblowing context, or if a report has already been made to a government agency like the SEC or the Department of Justice. On attorney-client privilege, whether an internal investigation is privileged can depend on the purpose of the investigation. As we indicate here, is more likely to be privileged if it's predominantly legal in nature and directed by counsel. Less likely if it involves routine business issues, even if it's being conducted in part by in-house counsel. Communications made for the purposes of enabling lawyers to advise the company, or that reflect the substance of legal advice, will generally be found to be privileged, but the underlying facts would not be found to be, are generally not perceived to be privileged information. Next slide, please. There's also the issue of work product protection that may apply if an investigation was initiated in anticipation of litigation, for example, in response to a government subpoena or an employee lawsuit. An SEC investigation would be, a situation where you could have work product protection develop, but that may not apply if the investigation is not predominantly legal in nature. The dividing line between factual documents and privileged documents can often be fairly thin and tricky assessment to make. As I mentioned earlier, even if an investigation is privileged, the underlying facts would not be, particularly if they're discoverable from a source other than the attorney-client communication. So if you, in the course of preparing materials that reflect information gathered in the course of an investigation through interviews or reviewing documents, the underlying documents would not be protected either through attorney-client privilege or work product, nor would the information, should it be obtained from an individual. Obviously, that individual is a source that can be contacted by a government agency or plaintiff's counsel in the course of pursuing their investigations or claims. In most cases, the ultimate resolution of the investigation will not be privileged, which I think leads to one of the next points. Laura, if you don't mind, go to the next slide. The question of written or oral reports. During the course of an investigation, counsel, whether in-house counsel or outside counsel, will prepare a number of reports. Outside counsel will typically prepare memos summarizing information that they've learned in the course of an investigation. written witness interview memoranda, and then final reports, which may or may not be in the form of written format or presented orally. Counsel are, typically and frequently asked to provide updates to the supervisor of the investigation. If they're outside counsel, they're asked to provide that to the inside counsel. Inside counsel may be required to provide those updates to general counsel or business leaders. Counsel typically write memos following employee interviews to document what was learned. And as I said, may prepare a written report at the end. There's I think a mixed question on preparing written reports at the end of an investigation. A number of clients we've seen prefer not to have written reports, but prefer to just receive them orally, because there's always a possibility that a written report may be requested by government agencies, like my former colleagues at the Securities and Exchange Commission. And then that opens up a whole dialogue with the agency about whether or not that report is protected either under an attorney-client communication or work product. And sometimes we've seen that clients have requested to not have them in writing to avoid that challenge. Next slide, please. As I mentioned earlier, in kind of the nature of scrutiny that can lead to internal investigations, whistleblowers are a common source of internal investigations, particularly in the ESG context, whether they're reported internally to the company or to the government. As Brian alluded to at the very beginning, there are a number of people who are pro ESG or anti ESG or in favor of certain issues and not others. And people within the company have a good insight into whether and to what extent a company is satisfying its representations, as Brian talked about, the communications that the best practices. Employees are often a source for the company and the government to question whether or not the representations that are being made in those communications are actually being satisfied. As we indicate here, the government's placed an increased emphasis on encouraging whistleblowing to the government, and particularly in the case of ESG issues, that's something we've seen more of from the SEC. The SEC created an Office of the Whistleblower in 2010. One of our partners, Jane Norberg, was actually one of the people who helped develop the Office of the Whistleblower and was the chief of the Office of the Whistleblower before joining Arnold & Porter 2 years ago. And as we've seen, the SEC has taken action against companies and individuals who have retaliated against whistleblowers or attempted to impede reporting out to the SEC. Sasha mentioned a number of an example of an SEC case where the commission found that efforts to constrain employees from reporting to the government resulted in a $130,000 fine against the company. And there have been a number of cases recently that have raised issues about companies' efforts to inhibit their employees from making whistleblower claims to the government, either to the SEC or the Department of Justice. Next slide, please. One of the other areas where we see ESG issues coming up is in the context of international investigations. Some of that can ultimately lead to government lawsuits. For example, the SEC case against Vale is one that seemed to be initially more of a traditional non-disclosure case, but the underlying issue really focused on representations about the company's environmental claims relating to certain dams, which ultimately led to I think, $57 million settlement with the SEC recently. From an international perspective, when conducting investigations, privilege laws can be very complicated when working outside the US. Different jurisdictions have different expectations about what information may or may not be available to collect from international employees, which can lead to challenging efforts to collect and review documents. Some jurisdictions, as we've seen, have very strict rules about what information can be obtained from employee personal devices, cell phones and iPads or the like being the typical area where non-US jurisdictions can be more challenging. Documents located outside the US that are brought into the US or can then become subject to subpoena by outside parties, including the government. There's also local labor laws that need to be considered that could limit the scope of conducting employee interviews and how those may be conducted, what types of questions may be asked, who may participate in those interviews. There's also jurisdictional differences in how misconduct can be reported internally and externally, and local attitudes towards obstruction of justice can be hard and involve sanctions. And these are all things that when you're dealing with an international context need to be considered and weighed in terms of how to go about pursuing information from employees that are not located within the United States. Next slide, please. Brian, I don't know if it makes sense if you have questions that flow from some of what Sasha and I have talked about before we kind of go into the key takeaways. And I don't know if we've received any questions. It might be a good time to open that up.
Well, I do have a lot of questions, but I don't know, maybe you'll answer them. So perhaps you start with your takeaways and then I'll.
Sure. So most importantly, care should be taken to determining the scope of the investigation. As we talked about previously, there are a variety of different ways that ESG issues can expand and spider out from an initial claim or initial reason to begin an investigation. So determining at the outset what's the scope of the investigation, what are the issues that need to be looked into is of paramount importance. In the course of conducting an investigation, counsel should think carefully about how to protect attorney-client communications, work product materials. Counsel should always conduct, direct, and oversee the investigation. So go ahead, Brian.
Yeah, I guess on that one, Christian, it strikes me specifically in the ESG context, just the issue of confidentiality. I understand what you're saying with respect to protecting attorney-client communications and from disclosure, but I think we have to recognize in the ESG context, these are oftentimes highly charged issues where the people you're interviewing, of course, they have a non-disclosure duty with respect to their company, but there's always a risk that because these are highly charged issues of great societal interest and importance, whether it's social issues or employee issues or environmental issues, they're very politicized and very often controversial. What steps in the ESG context in particular, what steps can you take to prevent somebody from leaking to media or to an alternative website or social media or something along those lines, if anything?
Sure. Well, you raised the point about non-disclosure agreements, and that issue alone may come down to what do the company's policies and procedures provide with respect to cooperating with internal investigations. There may be, companies should think carefully about what policies and procedures they want to have in place should an internal investigation need to take place. As Sasha mentioned, there are constraints that companies need to be mindful about with respect to constraining employees from, I don't want to say leaking, but making whistleblower claims to the government that, the nature of the confidentiality agreements, the repercussions, that's something that needs to be carefully reviewed so that, and there are a number of cases that have recently out of the SEC that have looked at improper confidentiality statements. In terms of reporting to the public or reporting to the news media or on social media, I think that's where the company's policies and procedures are really going to, govern what the consequences may be from that. And I apologize, I have in Washington, D.C., we get sirens a lot. So if you hear my siren, I apologize for that. But the, companies can have policies and procedures that involve consequences, including termination. And I'm not an employment expert, but that that could go so far as termination for revealing confidential information to the public, posting on social media, contacting the media. But obviously there are consequences that may flow from that as well. And if those types of actions were going to be pursued, you'd want to make sure that the employees hadn't also made a whistleblower claim to the government, or you could be seen as, then retaliating against someone for making a whistleblower claim. Does that answer your question, Brian?
Yeah, it's clearly, it just creates another, that risk creates, I think, suggest how important it is to be careful and delicate and when interviewing, as well as, there's just so many different components to that interview process that one has to be very cautious and careful.
Right. And I mean, kind of to the point you were making from the outset about a lot of ESG issues being very politically charged. You never know which side of the issue someone you're interviewing and working with, where they stand on something. So trying to be delicate and approaching it from, I guess I would say, like Joe Friday, just the facts perspective, is an important way to approach that interviewing process. So there's not a perception necessarily of one side or the other, just trying to get the facts and using that to figure out the next course and how to resolve the issue. Another key takeaway is determine whether or not outside counsel should be retained. As Sasha pointed out, inside counsel can often have their finger more on the pulse of the business and the employees, but there may be instances where bringing in outside counsel makes sense, particularly at the higher level of the organization, higher level the alleged conduct is implicated, may militate more towards bringing in outside counsel at an earlier opportunity. Or if there's legal counsel potentially involved in the underlying issue, whether it's relating to ESG disclosures and the involvement in counsel in that process, and if counsel was involved in making some of the not following the best practices that Brian talked about earlier, that might be an instance where you want to bring in outside counsel to get to an underlying understanding of how legal counsel was involved in that process. As in any internal investigation, you want to take steps immediately from the outset to preserve documents and cast a broad net on document retention and preservation obligations. Yeah, Brian, I think one of the things you mentioned earlier is just how expansive an ESG issue can be and how it can really flow into different departments. And so I think it's really important for companies when they're thinking about their document retention notices and which employees are the ones who are the likely custodians, to really think expansively about where that ESG issue may touch and who's involved in the underlying information. If it's concerns disclosures that are being made, or if it concerns evaluations of sustainability issues, who are the right people involved in that, and who should be contacted to make sure that information is being preserved appropriately.
Yes. For you and Sasha, a follow-on question from that might be, well, that I have is, kind of combining the points that that I was talking about at the outset, which is this concern that you could be completely accurate on a particular issue, but misleading by omission because you're not talking about the larger enterprise or the juxtaposition between that is the issue that you're communicating about in the broader context. How if you're doing an investigation about that narrow issue, clearly this could become all-consuming and too expansive. On the other hand, the investigation could be too narrow because it could miss the forest for the trees. So what's your advice, what's y'all's advice on kind of how to meet that balance? Of course, I know it will depend, but what are your thoughts on that?
Well, I think this is an instance that's a good question, and this is where I think you have that in-house counsel, outside counsel dynamic to think about. In-house counsel may be able to spot the trees without seeing the forest because they know the issue, they know the people. As they're thinking about that particular issue, it may make sense to even just consult with outside counsel to get a different, fresher perspective, people who are not, tightly tied to the company and its activities, so that you can have that dialogue about figuring out how much more broadly the investigation needs to be, other than the specific trees, as you put it, that are at issue. Sasha, I don't know, do you have additional thoughts on that?
Yeah, I think you covered most of it. I do think that outside counsel tend to be good at issue spotting because outside counsel have seen similar investigations. They have seen collateral consequences coming out of types of ESG issues. So it can be good to consult outside counsel, even if just for that small bit of it.
Great. Another key takeaway, as we talked about earlier, is giving careful consideration to the witness interview process, which order to interview the witnesses, as we suggested. Typically, you want to start with lower level employees, given the facts that they are more likely to know and have a greater flexibility or willingness to talk more openly. But if the issue is focusing on something at a higher level, or if it's being brought by a whistleblower, starting with that whistleblower, the higher level employees may make sense. Of course, in the course of conducting those interviews, you want to give appropriate upjohn warnings to all employees who are being interviewed, indicating that you represent the company and not the individual. And if there's a need for them to obtain their own outside counsel, that's something that should be considered. One of the key takeaways also, and I'm not sure, Laura, if you go next slide, I'm not sure we really touched on it, but there's, the question of what facts and conclusions of an investigation need to be shared with those who aren't involved in the investigation. There's external auditors, board of directors, other stakeholders, and you want to make sure you strike a balance between what legitimate stakeholders need and the need to preserve the attorney-client privilege. The company may have different privileges with respect to the auditors or the board members, and giving careful consideration to that is important. And with that, take care of memorializing the investigation and consider whether a written report or an oral report is more appropriate. Then, as we touched on very recently, in conducting internal investigation, it's really important to research the laws that are applicable in each of the local jurisdictions where employees who are going to be investigated or materials are going to be obtained, to make sure that that local laws are being complied with, both from the company's perspective, but also with respect to the implications those laws may have on employees cooperating with the investigation or not cooperating, as the case may be. And finally, understanding and being wary of special risks related to whistleblowers. The government takes a very, and particularly in this current administration of the Securities and Exchange Commission, takes a very critical look at how companies are handling whistleblower complaints, either made internally or to the government, and being very mindful of how those whistleblowers are treated is an important consideration in the course of conducting an internal investigation. I don't know if we have other questions, or I haven't been able to check to see if we've got any questions come in, but I don't know if you have others, or Sasha.
I have a question, Sasha. You want to, if you don't have one, I guess there are, again, going back to the point that I was making, that these are oftentimes in the ESG context highly public and controversial issues. I've been involved, and we didn't prepare for this question, so I apologize if I'm putting you on the spot, but I've been involved in some investigations where the decision was made at the outset essentially to not have anything privileged. The entire investigation was to be public. It was obviously a very public issue. Is that something that y'all have thoughts on, and when is that appropriate and when not?
Sasha?
Yeah, that's a very interesting approach, to have the entire investigation public from the beginning. I think you'd have to think about attorney-client privilege issues really carefully before you make that decision. But in certain circumstances, I can see why that type of transparency would be beneficial.
We did have a written question just come in. Should attorneys undertaking an internal investigation memorialize, possibly in a separate engagement letter, the scope of the internal investigation? I think that is, an important consideration for particularly outside counsel to think about. And, it would be wise to set the parameters of what the investigation is going to encompass, so that it, if the scope expands, there's an opportunity to revisit the engagement with the company and ensure that appropriate plans are in place.
Great. Well, I know we're getting close to time. I did want to make one correction to my comments, going back to the Canada Goose case, which I think I misstated and said, well, we're going to wait and see what happens. That case was, the motion to dismiss was denied in part, granted in part, and ultimately the plaintiff dismissed voluntarily with prejudice. So we do know what happened in that case. So apologize for that if I misstated that. Any closing comments, Sasha or Christian, as we close out the hour?
Nothing further on the topic. I just, Sasha, do you have anything further to add?
No, that's all for me.
Okay. Just bear with me. I want to make sure I have our right closing comments. So this concludes our program today. As mentioned earlier, we'll send you a follow-up email with a link to the evaluations, CLE credit information, and presentation slides. If any questions remain, I think our contact info is on the second slide. Please do not hesitate to contact us directly. And we thank everyone for joining and participating in today's webinar.